Court will come to order, and we call case number 645139, State of Texas versus Jacqueline Nicole Alanis. The charge is DWI, alleged to have occurred on August 20th, 2020. So it's 8/20/2020. State ready?
It's ready.
Defense ready?
Yes, sir. And I didn't get to say good morning. How are you, sir?
Good morning. Looks like you're celebrating St. Pat's Day.
I am.
Are you a little bit Irish?
I'm a little bit Irish, and my oldest son was born on St. Patrick's Day. So we also do a big birthday.
And what's his name?
His name is Caden, and he turns 11 today.
Payden with a P like Paul?
Caden, C-A-E.
All right. Why didn't you name him Patrick?
It seemed a little too me.
It seemed what?
A little too traditional.
Okay. A little hokey.
Little tradition. I would have gone for it, but I don't know.
Well, how old is the child?
He turns 11 at 4:20 p.m. this afternoon.
Okay, I'm sure he's already counting that he is 11 early this morning. All righty. State ready to proceed?
Yes, sir.
All right. Patricia, let's see. Ms.
Yes, sir.
Jacqueline Nicole Alanis, obviously you're part of a plea. I'm going to ask you to raise your right hand. You solemnly swear that in this proceeding, any information or responses you submit will be the truth, the whole truth.
Yes, sir.
Thank you. You may put your hand down. All right. Ms. Alanis, before we proceed, there's things that I need to talk with you about. Constitutional rights and protections that are involved here. Obviously, you've already reviewed the paperwork with your attorney, Ms. Ashley Morgan.
Yes, sir.
You have not?
Yes, my judge.
Yes.
All right, now, y'all are starting out giving me a bad time here. Ms. Morgan, as an officer of the court, you're telling me that you have had the opportunity and taken the opportunity to review the documentation for this plea?
Yes, Your Honor.
All right. Now, Ms. Alanis, by the way, are you in any way related to John, the late John Alanis, used to be a lawyer?
No, I am not actually.
Okay, no problem. The first thing that I have to talk to you about, these will be verbal discussions regarding constitutional rights and protections. And then these actual detailed rights and protections are going to be repeated 2 or 3 other times in writing in the plea documents. Do you understand?
Yes, sir.
First right is the right to remain silent. You do not have to make any kind of statements. You don't have to answer any questions. You don't have to submit any paperwork that has your signature, particularly papers that might admit or confess to wrongdoing. Do you understand you have that right?
Yes, sir.
And you're willing to give up that right and answer questions and submit paperwork. Is that correct?
Yes. No, wait, I don't know.
You're not sure. All right. We're going to let you visit with your attorney in a little while before we proceed, but there's other rights that are included. The right to a jury trial. You and your attorney can participate in selection of 6 people to hear the evidence and testimony and decide whether you're guilty or not guilty. It appears by participating in this plea agreement that you will be waiving the right to a jury trial. You also have the right to what's called confront witnesses. That means if you go to a trial, any witness who would testify, you and your attorney could ask questions, challenge them. That's called cross-examination and confrontation of witnesses. You'll be giving up that right. You also have a right called the right of appeal. That right means that you by yourself or your attorney by herself or the two of you together have a right to demand that a higher court review the record in this case and the evidence for whatever challenge you wanted to make. But when you do what's called a plea bargain, you give up that.
Excuse me, Judge, you froze when you said when you do what's called a plea bargain, you give up, and then you froze after that.
Well, I'm perfectly warm myself, but okay. Thank you, Kayleen. Now, when you do a plea like you're doing, you give up the right to a jury trial, and then you have what's called a right of appeal. That right means that you're giving up the right to demand after this proceeding that a higher court review the official record, which by the way is being prepared by Ms. Kayleen Juretta. You'd have the right to demand a higher court review that record and the evidence for whatever challenge you wanted to make. But in entering a plea bargain like you're doing, you give up that right too. Now, have you had a chance, do you understand the rights that I'm talking about?
Just a little bit, yeah.
Okay. Now, you also have a right to demand that this hearing be held at the courthouse in the public courtroom. Because of the pandemic, excuse me, because of the pandemic emergency, we're not doing these hearings at the courthouse in the courtroom. Where we're doing them is by video conference. Both you and the state have the right to demand that this hearing, the plea, be held in a public courtroom. We're doing it by video conference instead because of the crisis, the pandemic. Do you understand you're giving up the right to proceed in the courtroom and we're doing it by video conference?
Yes, sir.
All right. And in addition, that video conference is being put on YouTube. So anyone that wants to tune in, the public can see and hear everyone that's involved, yourself, myself, the other people, your attorney, the state's attorney. And they can see what we're doing in any kind of documents, whatever. That's a right that belongs to you and the state. Now, I'm showing you the first document. That is a document that starts off right at the top with information, basic information. Clause number 645139, the state of Texas versus Jacqueline Nicole Alanis in the county court in law number 5, Bexar County, Texas. Then it has the title of the particular document. This one says in bold print, all capitals, state's consent to video conference. I mentioned a moment ago that they have the right to demand that it be done in public, but they're agreeing to do it in video conference. It is signed by Andrew Harris Edelman, the assistant district attorney. The next document, it again starts off with the information, the basic information, court case number, your name, the court number. Then the title of this document is Discovery Acknowledgement. This one shows that the state and defense attorneys, your attorney and the state's attorney, have agreed that the state has complied with a law that's called Article 39.14 of the Code of Criminal Procedure. This document requires this, it complies with the requirement of the state that the state provides access to you of materials, evidence, documents, videos, whatever there is. They have complied with showing it to you, making it accessible to you so that you and your attorney could make a reasonable and informed decision. You'll notice it is signed by Mr. Edelman and by Ms. Morgan, your attorney.
Yes,
I
sir.
will be signing that document. This next document, again with the beginning introductory information, This document is titled Defendant's Consent to Video Conference. We just talked about that. Now there it is in writing. Do you remember seeing that and signing it?
Yeah.
Okay. This is a form that's sent to me, but the original you may have already signed it yourself. Now this next document is again with the introductory information. It is titled Defendant's Waiver of Constitutional Rights and Court's Admonitions. Did you review this with Ms. Morgan? It starts off with a declaration. It says, I, Jacqueline Nicole Alanis, you're giving up the right to have me read to you the official documents that charge you with DWI. Do you understand that you're making that declaration?
Yes, sir.
The second sentence says that you know and understand you're charged with the offense of driving while intoxicated and obstruction of a passageway, roadway, waterway. Then the next sentence says, in this cause, I hereby, that's you, enter a plea of guilty to the allegation of obstruction of a passageway, roadway, waterway. Now, the rest of this document is divided into 15 numbered sections or divisions. This first one, number 1, talks about how you can be punished for the offense. You're going to be doing obstruction of a passageway, so on and so on. There's little boxes stacked up vertically, and next to each one, there's a statement concerning range of punishment. The Class B is checked off. That means you know that that's one that applies to you. A fine of $0 to $2,000 in jail from 0 days to 180 days. That's how you can be punished. Do you understand that?
Yes, sir.
All right, number 2 talks about some specific rights. We talked about them all ago, but this one is in writing. Talks about jury trial, cross-examination of witnesses, and the right to remain silent. And then it declares, you declare, I freely and voluntarily waive or give up those rights. Is that correct?
Yes.
Number 3, have you ever had any mental issues or problems?
I mean, I've been hospitalized before, but I don't know if that's mental issues.
Okay, have you ever been given or taken medications for mental, psychological problems?
I've been seen before, and I have been told that I'm diagnosed with like bipolar and depression and anxiety. But this was like years back.
Are you taking medication right now for those maladies, for those problems?
No, I refuse to.
All right. So, number 4 talks about the plea of nolo contendere. This court takes a plea of nolo contendere as a guilty plea. And what you're saying here, number 4, is that after reviewing the evidence and information and listening to Ms. Ashley Morgan, your attorney, you believe it is in your best interest to plead nolo contendere to the charge of obstruction. Do you understand that?
Yes, sir.
All right, number 5, have you ever been involved in the sex offender registration program?
No.
No.
All right, number 6, this one tells you this, generally speaking, you and Ms. Morgan and the state through Mr. Edelman have made an agreement on what you're willing to do on this matter. Now, that agreement does not go into effect unless I okay it. As the judge, I have the authority and responsibility to decide if I accept your bargain or not. I also have the authority to give you a punishment within the range of punishment, and I can give you a punishment heavier than what you agreed to. But understand this, if I reject your plea bargain, your agreement, or if I give you a punishment heavier than what you agreed to, in that case, the law would allow you to withdraw your plea and start all over again. and nothing that you've said or signed up till now would be used against you. Is that understood?
Yes, sir.
All right. The right of appeal, which I will show you a document specifically about that in a moment. The right of appeal, you give up that right as part of the plea bargain, unless there's been motions filed and ruled on that you want to appeal. That's the only exception, but otherwise you're giving up the right of appeal. Is that understood?
Yes, sir.
All right, where were you born, ma'am?
I was born here in San Antonio, Texas.
Alrighty, then that makes you a U.S. citizen, and I'll show note in the paperwork. 9 and 10 do not apply to you. Now, is there going to be a deferred adjudication on this, Mr. Edelman?
Yes, sir.
All right. Number 10 applies, 9 applies specifically to you. Rather, 9 does not, but 10 does. Have you reviewed that with your attorney? No, 10 does not. That's the sexual crimes thing. Number 11 is the one that applies to you because you're asking for deferred adjudication, and it has specific rights that you have as a result of being granted, and you will be granted deferred adjudication. 11 and 12. Now, because you're entering a plea bargain, you're also giving up particular rights. Number 14 talks about a DWI, basically Chapter 49 charges. You don't need to worry about the numbers, but there are specific rights that you have concerning evidence, and you're giving those rights up on number 14. And number 15, you can demand that I stop everything right now and get what's called a risk and needs assessment. That would be a examination and gathering of evidence to determine things that I should look at or do for you as a result of your participation in the justice system. But you're giving up that right. Did you understand that?
Yes, sir.
All right. You reviewed this with your attorney. You'll notice right there in front of you is the document is signed by your attorney and the state's attorney.
I see that. Yes, sir.
All right, and I'm signing it myself as part of the pleading. Now, again, introductory information, and then there's a declaration that I make as a judge. Trial court certification of defendant's right of appeal. I, judge of the trial court, certify this criminal case, and then there's the 5th box. Next to each box, there is a declaration or statement concerning appeal. This one says, this is a plea bargain case and the defendant has no right of appeal. Do you see that?
I do. Yes, sir.
All right. You reviewed that with your attorney and your attorney has signed it. I believe you've now signed it. I will be signing it also. The plea agreement then? Oh, the application. Again, the application, this case is called, the document is called Application for Deferred Adjudication. Introductory information at the top. Then you make the declaration on the application. Did you review this carefully with your attorney?
Yeah. Yes, sir.
Remember when we talked about applying for probation and that we were going to ask for deferred adjudication?
Yes.
That's what.
Yeah. Okay.
Alrighty. Now, did you understand what you're telling me under oath by signing this document?
Yes, sir. I do.
All right. I will be signing it in approval. There's a certificate signed by your attorney. Then this one, in this case, is in front of me, it's blank. You may have already filled out one with your attorney. Name, home address. Are you employed, ma'am?
Yes, I am.
Who's your employer?
I work at Toyota of Bernie.
But Judge, she is going to be moving to Illinois. We're going to ask for permission to relocate.
Okay. And right now, are you full-time employed?
Yes, I am.
What do you do there?
I'm a receptionist for the service department. Basically just paperwork, lots of paperwork.
All righty. And what do you earn at this time?
I earn $13 an hour.
How long had you been working with them?
I've been with them for almost a year and a half now.
Very good. All right. Did you put in 3 names of referral people that will always know where to find you?
I did not, but I can do that.
Well, you'll need to, okay? It's required.
Okay, I never, yeah. didn't know.
Okay. Are you married or single?
I'm single.
All right. Do you have any children?
No, I do not.
Okay. Where were you born?
I was born February 3rd of 1997.
An Aquarian.
Yes,
Very
sir.
good. Have you ever served in the military?
No.
Okay. All right. The next document we'll have will be what's called a plea agreement. What's 37541? It's over your right shoulder. There's a box that says 37541.
Oh, I'm getting ready to move, so I have a couple of boxes in my car.
Okay. All right.
Yeah.
To the charge of obstruction. Oh, excuse me. Mr. Edelman,
Yes, sir.
what is the state's motion in reference to the original charge?
State moves to add count 2 to the information, obstruction of a highway, passageway, or waterway.
Defense, any objection?
No objection, Judge.
All right. Then that motion is granted. So now are we waiving the original DWI portion and proceeding only on the obstruction?
Yes, the state will additionally move to waive count 1 of the information and proceed on count 2, obstruction.
Objections, if any?
No objection, Judge.
Then we'll proceed on obstruction, which is count 2 of the original charge. Now, Ms. Alanis,
Yes, sir.
to the charge of obstruction of a passageway, highway or waterway, how do you plead, ma'am? Are you
Guilty.
pleading?
Guilty.
All right. And did anyone threaten you, intimidate you, or promise you anything other than the plea bargain for you, in exchange for you to plead guilty?
No.
All right. I'm now showing you a document called Plea Agreement. It's the only one that doesn't start off with a case number, your name, and the court number. But it does have it there with the exception of the court number. It says State of Texas versus Jacqueline Nicole Alanis, case number 645139.
Okay.
Is that correct? Hold on a second. Is that spelled correctly? Jaklynn? Yes.
Yes, sir, it is.
All right. Now, the first 2 boxes on there, I will be marking. The first one says that we've talked to you about your right to remain silent. The second one says I find that you are a U.S. citizen because you were born in San Antonio, you said. That'll be marked. Then there's a section coming up right here in front of you that says Defendant's Acknowledgements. There's 5 check marks, and each one talks about specific rights and protections that you know and understand. You've discussed them with your attorney, and you're giving those rights up. The following section is DWI specific allegations. The state has moved to, as we discussed, to amend it to include the charge of obstruction, and you have been very ably served by getting that for you because you're no longer in the DWI category. At the bottom, I will be marking, or Patricia have Ms. Flores mark on their motion granted, right there. And then the next section that applies. Before we go beyond that, Ms. Morgan, do you want to go into breakout with your client to be certain that she knows and understands these rights? There was some reluctance. I understand the nervousness of doing this,
Yes,
but I'd rather that you all take a break real quick and make sure she knows and understands what we're doing.
I agree, Judge. I spoke with Miss Allen yesterday, but she was also addressing some speeding ticket. And so she has a lot of stress right now with the move and understanding the different plea offers. So let me go ahead and do that.
All right, Patty, would you place them in breakout, please?
Yes, sir. It's breakout room 2.
Patricia, make sure that in my recitations on the record that I include the permission for her to change her residence to Illinois.
Yes, sir.
I don't think I'll forget, but sometimes I do.
Yes, sir.
How's Mama and Rose, Patty?
They're good, Judge. Thank you for asking.
Oh, and your son and your grandson, Mr. Everett?
También, todos bien, gracias a Dios.
Qué bueno.
I already have the 11 o'clock attorney Ivan Barrera and his client Keith Hernandez waiting.
Okay, and we won't be long. What do we have with Mr. Barrera? What is that?
It's a plea.
A plea?
See,
And on what is the charge, pray tell?
I'll let you take a wild guess.
Hmm?
I'll let you be 50% correct.
There's no way the judge will actually be able to guess this. It's impossible.
But yeah, he will. He'll be 50% correct. Pues,
Yes.
are you gonna guess?
Oh, no. I'm not in the profession of guessing.
Okay.
I speak only with certainty. Yeah.
Well, I have it as a DWI second.
What? A DWI?
Mhm.
Oh, I am chagrined. I'm so surprised. The rarity. Do I have anything after the 11 o'clock?
At 1:30?
Okay, yeah, that's fine, because at 12 o'clock I've got judges meeting. By the way, who was the attorney that we had a little problem with because he was shirtless in a hospital?
Shirtless?
Yeah, he had no shirt on. He was in a hospital bed, and a female, not the attorney was a male, but a female, I think it was prosecutor, was a little unhappy with that.
In your court, Judge?
No, well, the defense attorney was handling a case in County Court 5, yes.
I don't remember who
Maybe,
that was.
maybe it wasn't County Court 5, but one of the, oh, it was Judge Vara. It was in her court.
Oh, okay.
We had a defense attorney. He's a little bit chubby, non-minority, kind of a little bit curly haired, nice fella, but he was hospitalized and he wasn't wearing a shirt and he was trying to handle some legal matters. And I think Judge Vado was a little bit unhappy. So I called him and we had a little chat and he apologized, said that he was in a hospital and he wanted to take care of the matter, that he tried to pull up the blankets, but he realizes he was not that successful and that it was an unusual circumstance where he was hospitalized.
The only attorney that I know that was hospitalized recently, or two of them, Kirk Sherman and Kirby Johnson.
That's the one, Kirby Johnson. I called him up, had a little chat with him. I told him, look, anybody that's hospitalized does not have to appear in court, no matter what the circumstances. And that anytime we got on video conference, it was considered like being in the courtroom, and he sure as hell wasn't going to be coming into a courtroom in shirtless. So he was apologetic.
Well, Judge, court administration sent out to all the coordinators, and I believe the judges too, that, you know, the cases with Kirby Johnson were supposed to get reset 2 weeks, at least 2 weeks out.
Yeah. Well, this happened prior to that notice being sent out.
Oh.
He was trying to get the job or the work done, but it was obviously inappropriate. So anyway, for what that's worth, be aware. Let Mr. Barrera know that we shouldn't take more than 5 or 10 minutes maximum.
Yes, sir.
Ms. Luna, are you going to want to go into breakout with the young lady?
Yes, Judge, I need her information since she's moving.
Already, I'll announce that to him.
Okay, thank you.
Your Honor, will you excuse me for a few moments?
I will.
Thank you, sir.
Judge, Miss Morgan and her client are back.
Okay.
Oh my. Oh. And Judge, on Saying one thing we are going to talk to you about is on the ignition interlock. When Miss Alanis moves, and I can questions.
Excuse me, Judge, do you want me to go on the record or wait for Mr. Edelman?
We're going to wait for Mr. Edelman briefly.
Oh, okay. But when she moves, we're going to ask for in-home. She's not going to be taking her vehicle from San Antonio back to Chicago.
Oh my God.
Oh my God.
Excuse me.
Mr. Edelman.
Yes, sir.
All right, court come back to order on case number 645139. Ms. Morgan, are you satisfied that your client has fully understood the documentation and the consequences of this plea?
Yes, Judge.
All right. Then I have accepted your plea, Ms. Alanis, and the following is the decision. You are pleading guilty. The court finds that there is sufficient evidence to find you guilty, including your own plea. As a result, the following is the sentence. Patricia? You are granted deferred adjudication for a period of 12 months. You will have assessed a fine of $850 plus court costs. If you live up to 100% of the conditions of supervision, you will pay $650, not the $850. You will perform 48 hours of community service restitution. In addition, you will submit to a TAP evaluation and follow the recommendations. You'll have 6 months of ignition interlock monitor placed on your vehicle. It's my understanding and noted here on the file that you have already completed the DWI education program and the victim impact panel. Now, are you going to be employed in Illinois, ma'am?
I plan to be, yes, sir.
And do you have some kind of impression of what your income will be?
I believe about at least $15 an hour.
Okay. Excuse me a second. This is John Longoria. Judge, I'm in the middle of some court proceedings, but I will make it a point to call you after a while. All right, thank you. Bye-bye. I'm sorry, but when the commissioners call, I try to respond at least minimally. All right, $15 an hour, that's 600 a week. That is 24, about 2,600 a month. All right. I'll assess a supervisory fee of $29 a month. In addition, the court agrees to you're moving or transferring your residence from the state of Texas to Illinois. Do you know exactly in Illinois where you're going?
Yeah, I'm gonna go live with my parents.
Where though? You're not telling me the where.
What's the address?
Oh, 13585 West Wadsworth Road in Wadsworth City, Illinois, zip code 60083.
All right. Ms. Luna, you will, Ms. Alanis, you will be going into breakout shortly to talk to Maricela Luna, who's called the court's liaison officer.
Okay.
You'll have to share more information with her. Now,
Okay.
Did I hear you, Ms. Morgan, did I hear somebody say that she would not be driving a vehicle?
And I'll call her and put her on as a witness for that testimony.
Your word as an officer of the court is sufficient for me. You're saying she's not going to be driving.
She's informed me that she's leaving her vehicle here in San Antonio with her cousin, I believe. Is it your cousin?
My sister.
Sister. And her father is driving from Illinois to pick her up and drive her belongings back to Illinois.
And you're not going to be driving in Illinois, Ms. Alanis?
I'm basically going out there to work for my dad's company, so we work from home. So I figured not worrying about a car because I have a lot of stress and problems with the vehicle that I have now and a lot of money that I've already put into it. So I don't want to keep doing that, especially with this charge that I have. Can't really afford both right now.
And I've
So
also
it's-
affidavit of non-driving. When she signs this affidavit, she will not be driving, period. It's not a if it's convenient, Judge.
All right. Then upon submission of the affidavit of non-driving, the court will order that in lieu of the ignition interlock, she can have a portable in-home monitor device, whatever's available up in Illinois. That'll have to be arranged by the probation office. All right. Now, within 7 days, when are you moving, Ms. Alanis?
my last day is the 24th of March of this month.
All right. Within 7 days, I will require you to go to the court. The court offices are around behind the actual courtroom, and there's a hallway. You can find County Court 5 administration. You need to administer a thumbprint to the documents that are involved in the judgment and whatever. Be sure and do that. So, I'm doing, all right. Any questions, Mr. Edelman?
Nothing from the state, sir.
Ms. Morgan?
Nothing, Judge. I'll make sure on Friday she's going back to the municipal court to finish the speeding and the insurance thing, and I'll make sure she goes to County Court 5 on Friday.
All right. And Ms. Luna, did you wish
Yes, Judge.
Did you wish to have Ms. Alanis join you in breakout?
Yes.
Ms. Morgan, if you choose, you can join them. It's probation office material.
It's
Okay.
breakout.
Okay. Should I
Breakout
click
room.
join?
Yes.
Okay, I'll go now. Thank you, Judge.
All right.
Thank-
Good luck to all of you. Be blessed, be well, be safe. Good luck in Illinois, Ms. Alanis.
Thank you. I'll let her know.
All right, that takes care of this matter. Okay, now the court calls,
Case number
hold on, I gotta flip the page here on my pad. Yes, ma'am.
627-319.
State versus
Keith Hernandez.
Keith,
Yes, sir.
Keith.
Yes, sir.
The charge,
It's DWI second.
the date,
Do you have that, Andrew?
The date of the alleged offense was November 14th of 2019, sir.
all righty. The defense attorney is, you said Ivan Barrera?
Yes, sir.
And the plea is going to be to, the plea will be to what?
We will have a motion to waive the enhancement provision and proceed on DWI first served.
All right, that's not going to be a deferred, is it?
Correct, it will be for regular supervision.
All right. All right. On case number 627-319, state ready,
State's ready.
defense ready?
Defense is ready, Judge.
All right. Mr. Hernandez, would you please raise your right hand? And right now you're muted. There you go. You solemnly swear that in this proceeding, the information and responses you submit will be the truth and nothing but the truth.
Yes, sir.
Thank you. You may put your hand down. Mr. Hernandez, before we proceed, I need to discuss several rights and protections that you have by Constitution and statute. The rights I am discussing with you orally and throughout the hearing and the plea that's involved, the rights, most of them will be repeated 2, maybe 3 times in writing. And we'll discuss and cover those documents with you as we proceed. The first right I want to discuss with you is the right to remain silent. That means you do not have to make any kind of statement. You don't have to answer questions. You don't have to submit paperwork that has your signature, especially papers wherein you admit or confess to wrongdoing. Do you understand you have that right?
Yes, sir.
You also have very important rights like the right to a jury trial, the right to cross-examine any witness who would testify in a trial. You're giving up that right along with the right to a jury trial. You also have a right to have this matter held in public, in the courtroom. But because of the COVID pandemic, we're not holding these hearings in the public courtrooms at this time. Instead, we're doing them on video conference. You as a defendant and the state both have the right to demand that this matter be held in the public courtroom, but instead you and the state are agreeing to hold this matter by video conference. And in fact, it will be placed on YouTube and the entire world can see and hear the proceeding, can see us as participants, your attorney, the state's attorney, my court reporter, the everybody that's involved in this matter. You understand you're giving up the right to the public hearing and we're doing this by video conference.
Yes, sir.
Did you understand the other rights? The right to a jury trial, the right to confront witnesses, that is cross-examine them, and the right to appeal. There is a right of appeal. That's a right wherein you yourself or your attorney or the two of you can demand that the higher court review this proceeding, the record of this proceeding, and the evidence involved. That right you're giving up to when you enter into a plea bargain. Do you understand that?
Yes, sir.
All right. Now, have you reviewed all the paperwork in this matter with your attorney, Mr. Ivan Barrera?
Yes, sir.
Okay. Then we're going to start off with the document. The first one, all of them are going to start off saying the case number, the state of Texas versus Keith Hernandez. Then in County Court at Law number 5, Bexar County, Texas. That's the introductory information on all the documents with one exception. Then you have the title of the particular document. In this case, state's consent to video conference. That's the one where the state says, we're not demanding this hearing be in the courtroom. We agree and consent to the video conference.
I don't know what I did.
Pardon me? Is that at least one in the second round, huh? All right. All right, there's the one from the state. Do you see the document is signed by Mr. Andrew Harris Edelman? The next
Yes, sir.
document is what's called the Discovery Acknowledgement. It starts off with the same information at the top. Then the title of this document is Discovery Acknowledgement. We have a law that's called Article 39.14 of the Code of Criminal Procedure. That law requires that the state provide to you and your attorney the evidence, materials, information that is required by law and that allows you and your attorney to make an informed decision concerning this matter. This is signed by Mr. Edelman for the state and Mr. Barrera, your defense attorney. That is an agreement or an acknowledgement that the state has complied with that law. Now we have your written consent to the video conference. This one is your document wherein you have signed and said, I consent to the video conference instead of having this in the open public courtroom. The next document again starts off with the information at the top, identifying information. This one is titled Defendant's Waiver of Constitutional Rights and Court's Admonitions. It starts off with 3 individual sentences. The first one, these are all declarations by you. Number 1 says, I, Keith Hernandez. In your case, you're saying you hereby waive the reading of the charging instrument. In other words, there's a particular document that accuses you of the offense of driving while intoxicated, second, and that you don't need me to read to you. The second sentence, you declare outright, I know what I'm charged with, driving while intoxicated, second. In this, the third sentence, it says, I declare, I hereby enter a plea of nolo contendere to DWI. Now that means there will be a motion during this procedure wherein the state will reduce or waive the enhancement, the higher charge of DWI second. Do you understand that?
Yes, sir.
All right. Then the rest of this document is divided into 15 separate parts or divisions or sections. They are all numbered individually. Number 1 identifies what's called the range of punishment. You can be punished by fine or jail. And this one, at the very first little box, check mark, it says DWI first, which is what you're going to be pleading to. You can be fined anywhere from $0, no fine, to $2,000, and you can be placed in jail anywhere from 72 hours, that's 3 days, to 180 days in jail. Do you understand that?
Yes, sir.
All right. Number 2 in particular, I'm not going to go over every one of these, but number 2 in particular talks about the right to a jury trial, the cross-examination of witnesses, and the right to remain silent. You declare here that you freely and voluntarily give up those rights. Is that true?
Yes, sir.
All right, number three, have you ever had any kind of mental problems or issues?
No, sir.
Have you ever taken or been given mental health medication?
No, sir.
All right, did you understand number four that says you're saying I'm pleading nolo contendere because I reviewed everything in my attorney's advice and it is the best thing for me?
Yes, sir.
All right, have you ever been involved in any sex offender registration program? Mr. Hernandez?
Sir.
Have you ever been involved in the sex offender registration program?
Yes, sir.
You have. All right. You'll notice that item in specific talks about some consequences that there may be. Did Mr. Barrera discuss those with you?
Yes, sir.
Item number 5. Okay. Number 6. That one tells you briefly that any plea bargain that you made has to be approved by me. I have to accept it or reject it. Also, I can give you any, number 7, unless there's been motions filed and ruled on by me, you will not have any kind of right of appeal. But number 6 in particular says that it is my authority and my responsibility to decide whether we accept your plea bargain or reject it. If I reject it, then you have the right to start all over again. If I give you a punishment greater than what you agreed to within the range of punishment, then you can, if I give you a heavier punishment, then you can also start all over again. And none of this at all would be used against you. Is that clear?
Yes, sir.
All right. The number 7 talks about specific, I don't think it applies, Mr. Barrera. You didn't file motions that were ruled on, right?
That's correct, Judge. We did not.
All right. Number 7 is not applicable to you. Number 8, where were you born, sir? Mr. Hernandez?
Here.
All right.
San Antonio, Texas.
I will be noting in the file that you are a U.S. citizen. Number 9 does not apply to you because this is not a family violence issue. Number 10, did you discuss that with him, Mr. Barrera?
I did, Your Honor.
All right. Number 11 does not apply to you because you're not being given deferred adjudication. 12 does not apply. All right, 14. 14 does apply. This one talks about evidence that's involved in this case. You're giving up the right to demand that they keep the evidence for at least 6 months. You understand that?
Yes, sir.
Number 15 talks about specifically that you can demand that I stop everything right now and get what's called a risk and needs assessment, things that might be helpful to you. But apparently you're willing to give that up. Is that correct?
Yes, sir.
All right. And you reviewed these documents with your attorney and it appears that you've signed them?
Yes, sir.
All right. The next document, it talks about where I certify your right of appeal, which is you do not have a right of appeal. The 5th box of the vertical boxes next to which there is a declaration of the right of appeal, some declaration or statement. The 5th box I'll be checking off says this is a plea bargain case. The defendant has no right of appeal. Did you know and understand that? It appears that you signed this.
Yes, sir.
All right. The next document is application for judge-ordered community supervision probation. Did you review and sign this?
Yes, sir.
Did you know and understand what you're telling me and committing to by signing this?
Yes, sir.
Now, you need to understand clearly that probation is a written, legal, binding agreement between you and this court. The agreement is that I will give you a jail sentence, but I'll suspend that. It's called placing you on probation or community supervision. But that is based on your living up to 100% of the conditions of supervision. If you live up to all conditions, then you don't come back to this court again for any kind of hearings. If you violate the conditions, either by refusing to live up to them or failing to live up to them, then the state can ask me to give you official notice, bring you back in for a hearing, and if the evidence substantiates it, we can and will put you in jail. Is that understood?
Yes, sir.
100% completion of the conditions. All right.
Yes, sir.
The next thing is called the plea agreement. Well, pardon me, there's a personal data sheet. Did you fill this out completely?
Yes, sir.
You're employed, you're unemployed? How long have you been unemployed?
It's going on about a year. When
Is
COVID,
that-
it was when COVID hit, I had got released because of COVID.
Okay. What does it look like for going back to work?
I'm hoping they try to rehire me once it's kind of closed down, but it looks like hopefully within the next month or two they'll.
Where did you work?
I was working for the post office inside the airport,
Okay.
but right now because I got have unemployment, so of course every week I have to at least put in 3 jobs in every week. So
Right.
if something comes up better, faster than hopefully going back to my job, then I'm gonna take whatever comes my way because I have children. So
Okay. Where were you born?
and here in San Antonio, Texas,
Okay. And you have no dependents, 0 children.
I have 3 children.
How many?
3.
3?
Yes,
What are
sir.
their ages?
My youngest just turned 1, my middle child just turned 5, and my oldest is 10.
All right. All right. Did you serve in the military?
No, sir.
Okay. And a vehicle, what did you have when you got arrested?
I it wasn't mine though.
Whose was it?
At the time, it was the mother of my child.
Do y'all live together?
Not no more.
Are you paying child support out of your unemployment?
Yes, sir.
All right. What vehicle does she have?
She had a 2000. It was a 2013 Camry SE, black.
So where the children live with their mom?
Now they do. Now they do. Yes. But my oldest, I have 2 mother of my children. One, my oldest lives with her mother, and then my 2 youngest stay with me most of the time.
Okay. All right. You'll notice now it's being shown to you. It's called a plea agreement. It says Keith
Yes, sir.
Hernandez, case number 627-319. It's got the 2 top boxes checked that I've talked to you about and explained to you your rights, especially the right to remain silent. Then I've marked the defendant as a U.S. citizen. Then we have defendant's acknowledgements. There's 5 boxes that talk about the different rights, constitutional and legislative, that we have talked about concerning your constitutional and rights and protections in this matter. Did you see and understand those check marks?
Yes, sir.
All right. The state has made a motion. Well, for the record, Mr. Edelman, what is your motion?
State moves to waive and abandon the prior conviction enhancement and proceed as an unenhanced DWI.
And defense, any objection?
No objections, Your Honor.
Very good. Then it's already checked off that that matter is granted. The motion is granted. We're proceeding on a DWI misdemeanor B. To that charge, Mr. Hernandez, how do you plead?
No contest?
Very good. Again, I remind you, a no contest plea is considered a guilty plea by this court. Is that understood?
Yes, sir.
All right. Based on your plea, and the evidence, I find you guilty. You're sentenced to 6 months locked up in Bear County Jail. That is probated or suspended for months. During that time, you will perform the following, or live up to the following conditions. There's a $500 fine, but if you live up to 100% of the conditions of supervision, I repeat, live up to 100% of the conditions of supervision, then you will pay $300 and not $500. You will perform 60 hours of community service restitution. You will also appear in the offices of County Court of Law number 5. Those offices are in the hallway behind the main courtroom. You will submit with the assistance of personnel, you will have your thumbprint placed on the documents, particularly the judgment in this matter. In addition, you will participate in good faith, enroll and complete the DWI intervention program, the DWI Victim Impact Panel Live. You'll submit to a TAP evaluation and the following recommendations, and follow the recommendations. You'll have 6 months of ignition interlock on the vehicle to which you have access. If you don't have access to a vehicle, then I'm going to need you and your attorney to submit immediately a sworn affidavit on your part saying that you do not have access to a vehicle and you will not be driving at all during the entire 12 months. Is that understood?
Yes, sir.
If you get fortunate and you are able to obtain a vehicle or you get access to one, you cannot drive it unless you come to the court and ask for permission and have an ignition interlock placed on that. Do you understand?
Yes, sir.
All right. Your supervisory fee at this time will be set at a minimum of $25 per month. Now, if you decide that you want to play games with the court and you don't finish 100%, then what's going to wind up ultimately happening, Mr. Hernandez, is we'll bring you back in. If the evidence supports it, then we're going to go ahead and sentence you to jail and make a final conviction. That final conviction will also result in the state assessing something like a $5,000 fine because this is your second go-round. Do you hear what I'm saying?
Yes, sir.
It's in your best interest to follow the line. If you don't, you're screwing yourself because not only will we put you in jail, the state will come in after that and charge you another $4,000 or $5,000 in fines. On the DWI first alone, it's $3,000. Then it goes up to $4,500 or $5,000 when you do a second one. So follow the law, follow the rules. Now, let me say something to you. The very worst thing that could happen in your life is if you decide to drink and drive and you go out and have an accident and kill your own children. That'd be the worst thing could ever happen to you. Do you think it can happen?
Yes, sir.
Well, yes, it happens all the time. People have accidents, kill their own kids, only because they didn't follow the rules and stay away from alcohol and driving. The second worst thing for you is if you have an accident and kill some innocent person that is not related to you because you're drinking and driving. That will wind up with you being sent to prison for a minimum of 20 years. Let me remind you that the third time you get another DWI, I hope you don't, then you're looking at felony, going to state prison because you already got two on you didn't get a conviction on literally was called a DWI second, but you got two of them now. So that means that the next one is felony, state prison. And there ain't none of this like you're doing right now. Do you understand?
Yes, sir.
All right, be careful for your own good and more importantly, your children's own good. If you were wound up going to prison for 20 years, think about that. 20 years of your little kids not having you around. Somebody else will take your place, maybe more likely, because I'm sure you got young wives or young mothers. So they'd want to have some kind of life, even if you don't. But where's your children? Where are they going to do it? You better think about that. All right. Any questions, Mr. Edelman?
Nothing from the state, sir.
Any questions, Mr. Barrera?
Yes, Judge, just one. When I was reviewing the documents with Mr. Hernandez, he did advise me that his vehicle is going to be repossessed soon. He does have the ignition interlock. Obviously, when his vehicle does get repossessed, he won't have one. So, if there's no objections from the state, if we could switch over to either the Scram or the Smart Start Mobile.
Mr. Barrera, once the vehicle gets repossessed, you come in and make that request. For right now, the ignition interlock continues. If it gets repossessed, the court will certainly consider an immediate order to remove the ignition interlock and then submit him either to Scram or to portable monitor, one of the two.
Understood, Judge.
All right. Anything else, Mr. Barrera?
That's it for me, Judge.
Please talk to your client. Make sure he understands what I have said. All right.
Will do.
Thank you.
Thank you,
You have a
Judge.
question, Mr. Hernandez?
Just one quick question about the community service, the 60 hours community service. Am I able to pay a donation for that?
Yes, sir.
Okay.
I will authorize donations. My preference is the Gabriel Project, but you can also choose to make donations to the San Antonio Food Bank. Ms. Maricela Luna will help you momentarily. You're going to go into a breakout room with her. She's going to want information from you, and she's going to give you some instructions. The donation will be at $10 an hour. Is that understood? So you have a
Yes, sir.
choice. You can do either one or both. You can combine them however you want to. You will have 60 hours to do. And you can either do them or pay for them. Okay, any other questions, Mr. Hernandez?
No, sir. Thank you very much.
Ms. Luna, any questions?
No, sir. I'm just gonna get with him in the breakout room.
All righty.
Thank you, Judge.
Thank you. Then, Patricia, we don't have anything else this morning, right?
Correct.
All right. I've got a meeting shortly. All of you be blessed, be well, be safe. I'll